Thank you very much, Your Honor. My name is Celine Humphreys. I represent the plaintiff, Mrs. Collar. I would like to reserve 5 minutes for a rebuttal argument, if I may.
What'll happen is that 15, it belongs to you, so when it gets down to 5 now, you'll get a yellow light saying, okay, you're into your rebuttal.
Gotcha. Thank you. And then before I launch in, I did want to take a moment to thank Your Honors for giving us the opportunity to appear before you on our appeal. Climbing right in, I want to give you context before I discuss the 2 errors made by Judge Cox in this trial. The context here is the very first question on the verdict form in the Ingle case, and that is the question of class membership. What occurred to me, though, is this court might not be aware, well, actually, let me step back. You might not be aware that this court has addressed more Ingle progeny cases than any other DCA in the state of Florida. But what you might not know is that the plaintiffs, the majority of the time, don't win these cases. Most of the appeals, I would say at least 95% of the appeals you see are appeals of verdicts for the plaintiff. But in fact, the plaintiff loses these cases more often than they win. And the reason is the context for the issues, the errors committed here. It's that very first question that the jury has to answer. Is this person, here is Ms. Collar, a member of the class? And that is the question of addiction causation. And when we lose, you can look at any verdict form in this court's jurisdiction. When we lose, it is always on that first question, because of course, that's the one that destroys any possible liability for the individual counts that you all have talked about. So that's the context of why what we're talking about is error and why it is harmless error. If you don't mind, I'm going to jump in and start first with the concurring cause instruction, because I think that'll give us context for then arguing about the additional error committed by Judge Cox on only allowing our treater to give part of his expert testimony about addiction. Concurring cause. Judge Sicklin, you've been on a number of panels that have touched on this, including the Tulo case and even the Cohen case, where you referenced a lot the Whitney decision out of the First District Court of Appeal. The issue on addiction causation is, did this individual have an addiction, and did that addiction to a nicotine drug that impacts the way the brain functions, cause that person to continue smoking? And the jury was given the definition of causation from the standard jury instructions on how you talk about addiction causation. We asked the court, could you please, Judge Cox, instruct the jury on concurring cause? And she refused.
Let me ask you this, though, on that very initial question.
Yes, sir.
Of whether or not the expert here was qualified. As you know, your opponent basically suggests that you bore the burden here of establishing to Judge Cox's satisfaction that the testimony in question here satisfied the requirements of Daubert. So they're, I guess, now suggesting you can't be heard after the fact to come back and say, sorry, you didn't meet your burden at the trial level. How would you respond to that?
Okay, that's the other error committed by Judge Cox, and honestly, Your Honor, it's more than just the allegation of the exclusion of his evidence. It's 2 errors. I'm going to answer you, but I really quickly want to tell you, even if you think I'm wrong and I'm not making a good argument, it doesn't matter, because she inconsistently applied her ruling. His testimony was part and parcel all about addiction. Was Ms. Collar addicted so that it caused her to keep smoking? And did she have the ability to fight that addiction, just like a heroin addict or a cocaine addict, and stop smoking? She allowed only that second testimony about the ability to break an addiction, the ability to quit smoking, which is an expert opinion on addiction, and did not allow the first one. So honestly, that's my easiest answer on why Judge Cox committed error when it came to our expert witness. Only half of his testimony, and I say expert witness, remember, this court knows, again, better than any other DCA, the concept of a hybrid expert, and that is a treater. When a treater comes in and is giving testimony. Here, this is the man that treated her for her COPD and prescribed to her drugs for treating that addiction, for example, Chantix.
But he did testify that he, in his words, was not an expert, didn't he? And he also stated that he didn't know how much or how often she smoked.
Those are 2 different questions, and I disagree on both. So first of all, he agreed to the extent that he was questioned by defense counsel, is this what you do? Are you some addiction expert, that you're out there trained in addiction with a degree in addiction, that you've been licensed somehow to treat folks with addiction, having some sort of let's say, a psychological, like a psychiatrist type training. No, this is a medical expert. But he did say, absolutely, I'm an expert by virtue of being a pulmonologist. Pulmonologists treat people with lung diseases. The vast majority of people with lung diseases sustain those from smoking cigarettes. And his treatment for her COPD was to stop her from smoking, to determine that she needed help stopping smoking. As he does with all of his patients, he had to decide, is this woman addicted? That's where the testimony comes from, Your Honor. He determined that she was addicted, and therefore he prescribed drugs.
What about your opponent's suggestion, though, that you concede that that this doctor really was not qualified to speak about addictions generally, yet, on the other hand, you say, yes, but this doctor did have the necessary expertise to opine that Ms. Collar, in particular, was addicted?
There are actually two different opinions. One of the things that we see in these cases, Your Honor, and I think it applies to others, but these are the ones that I've come to know, is that you can have experts from different fields of study who their testimony might overlap. Sir, were we able to ask Dr. Sue and stuff about, tell us like the context and the history of addiction, tell us what research has been done about addiction, tell us about the neurological connections and explaining addiction? No, sir. He's not a scientist who has devoted his life to studying and explaining the whole concept of addiction. But that's okay. As a medical doctor who has to understand addiction and diagnose addiction to treat his patients that are suffering from diseases caused by smoking, he is an expert in whether or not a patient is addicted. And that's all that we offered him for.
So let me ask you on this thing. Suppose we agree with you on the closing argument issue with the way the judge handled the expert testimony. We remand this case for a new trial. One of the things I've been struggling with is what should we tell the trial judge about what standard the trial judge should apply to expert testimony on retrial. And and it would really be, we would also be speaking not only to the trial judge who handles this case, but to any trial judge in this district until this is finally resolved. I mean, do you have any suggestion about where the Supreme Court has left us on that issue? We had you file supplemental briefing on that, because that's really beyond this case. That's a major concern to lawyers and judges everywhere. So do you have any insight as to that?
Yes, and as an appellate lawyer, frankly, I think that's one of the fun issues in this case is where do we go from here? Fun when you're trying to figure out the path of the courts and what the Supreme Court's going to do. I think this court, though, has already answered that case for itself with your Brunin decision saying, to the extent that it's procedural, and now the Supreme Court has embraced that to the extent it's procedural. So what we did in our...
What does that mean?
In other words, to the extent that, I know I'm doing the shorthand speak, right? So...
No, I understand that. I understand that. But isn't that sort of dodging the issue? I mean, the Supreme Court has dodged that issue, really since, for 3 decades. They haven't said whether evidence is procedural or substantive. But, I mean, at some point, they're going to have to really decide whether expert testimony is the standard is procedural or substantive. So we could dodge it that way also and just sort of pitch it out. But do you think that that's an intellectually honest way to do it?
Well, since you phrased it that way, no, sir, I don't. And that's why I dug in and geeked out and looked around the country and particularly gave you cases of the federal courts answering this exact question and some other states, including state Supreme Courts, saying that when you're looking at the issue of whether or not expert witness, in other words, the testimony that's going to come in and how we allow that testimony to come in, that is considered part of the trial mechanics. And that's the buzzword in Florida case law about is it procedural, is it substantive? Substantive is the stuff of what is my right that I'm enforcing, or what is my right that was violated that I'm seeking redress for. That's substantive. So when you look at all the federal cases, and it's interesting, when you do federal litigation, and my take on it at least is, if you look long enough, you can find a federal court to say anything, because there's, they're all over the place, but there's a pretty decent amount of uniformity in the federal case law that when it comes to this issue regarding expert testimony, it is in the procedural camp. So the federal courts say, hey, yeah, we may be applying your state substantive law, But this is procedural. We're applying our law when it comes to what caliber of testimony we'll allow in our courts.
Do you think those cases, those federal cases, are analyzing the issue in the same way Florida cases do on the Florida Constitution procedural substantive issue?
That's a very good question. It is very close. There are nuances that are different based on the fact that we're looking at Florida's Constitution versus the analysis. But when you read in those decisions, that's why I gave you so many, the analysis jives exactly with Florida Supreme Court precedent and decisions of this court as far as how we're going to break this out. I am at 5 minutes. I don't know if I've addressed enough my concerns about concurring cause. And Judge
I
Kuntz,
just
did
wanted
you
to
have a
ask one more
question?
question there. Putting aside the federal courts, our Supreme Court has ruled that this evidence statute does not apply retroactively, and they do that when something is substantive. When it's procedural, it applies retroactively. When it's substantive, it doesn't. So how do we put that together with what you're saying about it being a procedural statute as opposed to a substantive?
I should have said that in my brief. So that's a perfect point. The fact that this is a procedural issue means when the case goes back and is retried free of both of these errors, it is not a substantive law that is now going to be applied retroactively. It is in the nature of a procedural law that will govern the new judge trying the case by allowing concurring cause on both addiction and reliance, as was done here, and allow the treating physician to give his full expert opinion on causation. I'm going to sit down so I can have time to chat with you on rebuttal.
Thank you.
Good morning, Daphne O'Connor on behalf of Appali, Philip Morris USA, and also arguing this morning on behalf of R.J. Reynolds Tobacco Company. This court should affirm the judgment below because the trial court did not abuse her discretion either in not allowing Dr. Sewin's addiction opinion or in denying the concurring cause instruction. Turning first to the expert issue, it's of course a fundamental maxim of constitutional law that the court need not or should not reach constitutional issues when there are other grounds to effectively dispose the case. And here, there are three non-constitutional reasons that the court can affirm the trial court's exclusion of Dr. Sewin's testimony. First, regardless of whether Daubert or Fry is the law, it was the plaintiff's burden to establish that Dr. Sewin was qualified to give his opinion and that he had an adequate foundation for that opinion. They did not. Second, even if the opinion should not have been excluded, it's harmless error because it was a cumulative opinion of both Drs. Nyora and Dr. Manino, two expert witnesses for the plaintiff who also testified that Ms. Collar was addicted to nicotine. And finally, plaintiffs have waived their argument that 90.702 is unconstitutional. They did not raise it in the trial court. Indeed, they invited the trial court to apply Daubert when they challenged Dr. Tickner, the defendant's expert, and they also told the court it was duty-bound to apply Daubert. So that argument is waived.
Isn't that different? If we were going to reverse on other grounds, isn't that a different question as to whether they waived it at the last trial? As Judge Gross said, wouldn't we need to give some instruction as to what is to happen on remand?
That is true, but in terms of looking at this case, if you just look straight at the qualifications issue, that requires affirmance here because it was their burden to establish that Dr. Sewin was not qualified, and they didn't bring him live to trial. They relied on a deposition that was taken by the defendants in the case. That deposition transcript did not establish his qualifications. He specifically said that he didn't have special training in addiction. He also said initially that he was not an expert in addiction. And the courts in the state have held that even if you're an expert for certain purposes, you need to have, if you're relying on your experience, you need to have experience that qualifies you for the specific subject matter on which you're testifying. And in this case, they failed to do that. Now, the court did tell them they could bring Dr. Sewin live, have a Daubert hearing, or bring him live, but she made clear that based on the record she had before them, which was just the deposition taken by defendants, his qualifications were not enough to allow him to give the addiction opinion. And on the foundation point, regardless of whether Daubert or Fry applies, you still have to have an adequate factual foundation for an expert opinion. And here, when Dr. Sewin was deposed, he did not know that Ms. Collar had stopped smoking for 13 years, from 1993 to 2006, which is 13 of the years he was treating her. He didn't know how she had stopped smoking or what method she had used or whether it was difficult. He also did not diagnose her with addiction during his care and treatment of her. They designated him as a hybrid expert witness and wanted to have him give that opinion at trial as an expert, but that was not part of his care and treatment of her. And so because there was no factual foundation, that was another basis in which the court excluded the opinion. And either of those, qualifications or lack of foundation, both apply regardless of whether Daubert or Fry is the rule. Now, even assuming that the opinion should not have been excluded, it was cumulative. Both Dr. Nyora, who was a clinical psychologist and testified for a day and a half, and Dr. Manino, who was also a pulmonologist, just like Dr. Suen, gave the opinion that Ms. Collar was addicted to nicotine. And Dr. Manino came live. They established his qualifications on the record. He testified that he had read the literature on nicotine addiction. He had published articles on nicotine addiction. He had a grant from a pharmaceutical company to study nicotine withdrawal. And for all of those reasons, the court overruled the defense objection to his qualifications and allowed him to give the addiction opinion. And in the Vargas case from the 3rd DCA, of course, expert testimony, you don't need multiple experts on the same subject. So Dr. Suen's opinion was cumulative of Dr. Manino's opinion. And for both of those reasons, I think the court can affirm the trial court's decision not to allow Dr. Suen's addiction opinion. On the waiver point, plaintiffs concede that they didn't raise the constitutionality of 90.702 in the trial court. They argue here that it would be fundamental error, that it was fundamental error, and so therefore this court should consider the issue. But fundamental error in this court's Mormon case is to be applied very sparingly, guardedly. It's exceedingly rare in civil cases. The only case that the plaintiffs cite is the Trushin case, which was a criminal case of the Florida Supreme Court. And there, the Florida Supreme Court did consider the constitutional issue. The defendant in that case was being prosecuted under a criminal statute for vote buying, and the court did decide that that was fundamental error and they would consider it. But they also said very clearly that you can waive constitutional infirmities. And because this issue wasn't not only not raised below, but the plaintiffs themselves argued that Daubert applied and that the court was duty-bound to apply Daubert, I think the invited error would overrule any fundamental error argument here. So for all of those reasons, the trial court should be affirmed on the decision to exclude Dr. Suen's opinion. Moving to the concurrent cause instruction.
I mean, could you address, say, the thing that is really of concern to me is, and I think it's the toughest part of your case, is the flip side of excluding Dr. Suen's opinion while allowing his testimony to be used on the other side. I mean, that's really the weak part of your case. And why isn't what's good for the goose is what's good for the gander? Why shouldn't that have applied in the trial court? I mean, it seems unfair, and it seems that your side very effectively was able to use his addiction testimony to its advantage and an excellent closing argument, but they beat him over the head with that with Dr. Suen's testimony that if it shouldn't be allowed, certainly it's not. You won't be able to get by Special versus West Boca.
Right. So it is true that the trial court allowed Dr. Suen's testimony on his factual observations regarding Ms. Collar's smoking. So, for example, and that's another reason that I believe you could make the argument that there is harmless error here, because he was able to testify that she relapsed when she smoked, that she struggled to quit, that she had various side effects when she tried to quit. So he was able to testify to those factual reasons. She also let him testify that she was able to quit when she was motivated, which is the sentence that
the difference. That goes right to the heart of addiction. I mean, that's an addiction opinion that the trial judge disallowed initially. And he certainly, if he wasn't qualified to give that opinion on the first instance, he certainly wasn't qualified to give it on the second instance. So, I mean, I don't see, it seems to me that you were very, very powerfully argued why he shouldn't have been qualified, but, you guys weren't consistent and the judge wasn't consistent at trial.
So on the issue of whether she was motivated to quit, I mean, obviously Ms. Collar did quit for 13 years from 1993 to 2006. And Dr. Suen, when asked, was she able to quit when she was motivated, the answer was yes. And it is true that that factual testimony was used by the defendants in arguing the case. To prove class membership, plaintiffs have to prove both that the plaintiff was addicted and that the addiction caused the injury. And so defendants argued, of course, that if she could have quit when she wanted to, then the addiction didn't cause her injury. Regardless of whether if Dr. Suen had said she was addicted, defendants would have made the exact same argument. If the court had allowed in both his testimony that he believed she was addicted and he also believed she could quit when she was motivated, none of the arguments would have been any different. Defendants would have made the same argument that regardless of whether she was addicted, she was able to quit.
But if we decide that that was error to have let that in, and they preserved that point, one of the things we look at under Special versus West Boca is whether or not the party utilized that testimony, the offensive testimony, in closing argument. And your trial lawyer was eloquent in using that testimony in closing argument over and over again. So it seems to me that if we do decide that that's error, that, I mean, why isn't that, why wouldn't Special versus West Boca compel us to reverse for that reason alone?
Well, I believe that it was factual testimony that was being used to argue a factual issue, which was a quintessential issue for the jury. The question of whether she was addicted and whether the addiction caused her injury is a quintessential factual issue for the jury. The plaintiffs here, it is true that Dr. Suen was not permitted to say she was addicted. And they certainly argued in their closing argument that even if she was addicted, even if she could, that just because you're addicted, of course, doesn't mean that you cannot quit smoking. And they argue that both of the addiction and the ability to quit both are concurring causes, which is the basis of their argument relating to the concurrent cause instruction. But in any event, I do believe that the fact that Dr. Suen was not qualified as an initial matter gives the court the basis to affirm below. On the concurring cause instruction, in this court's Tulo decision, the court stated that concurring cause instruction, when the only concurring cause is the plaintiff's own negligence, the concurring cause instruction is redundant and not mandatory. And the notes on use for that instruction also state that when the trial court finds it's necessary, they can give a concurring cause instruction. But here, the legal cause instruction made clear that addiction didn't have to be the only cause. So the legal cause instruction said addiction needed to be a legal cause, needed to be a substantial contributing factor. But it did not say it had to be the only legal cause. And in closing argument, plaintiffs relied very heavily on that legal cause instruction and made it very clear to the jury that addiction did not need to be the only legal cause. So under Tulo, I think this court needs to affirm the trial court's decision. It certainly wasn't an abuse of discretion not to give that instruction. In Tulo, it also was not an abuse of discretion to give it. But because the concurring cause instruction is repetitive of the legal cause instruction, I don't think it's required in these circumstances. And certainly was not an abuse of discretion not to give that instruction.
Let me ask you along those lines, though. Your opponent argues that, actually, I found this interesting, and you mentioned it just now. In their initial brief, they said, the appellant indicated, as an initial matter, in Tulo, the defendants appealed the trial court's decision to give the concurring instruction. This court found there was no such error. So nothing in Tulo says that it is error to give a concurring cause instruction in an Engel progeny case. Talk about that a little bit, about the whole issue of the decision to give the instruction to begin with.
Right, so you're correct. In Tulo, the actual holding was that it was not an abuse of discretion to give the instruction. But in discussing that holding, the court also stated that the concurring cause instruction is not mandatory and indeed is redundant in a case where the only concurring cause is the plaintiff's own negligence. And if you look at the notes on use, they specifically say that the concurring cause instruction doesn't provide any new law or new elements. It's somewhat repetitive of the legal cause instruction, and for that reason, the trial court can give it when it believes it's necessary, but it's not an abuse of discretion to choose not to give it in a case like this. And there are multiple other cases. including just a moment, the Parker case out of this court, the 4th DCA, La Petite Academy from the 5th DCA, and Wedden from the 2nd DCA. In each of those cases, the court said when the only concurring cause is the plaintiff's own negligence, a concurring cause instruction is not required. And so if it's not required, it certainly can't be an abuse of discretion to choose not to give it, which Judge Cox did in this case. Thank you.
Great, thank you.
I'm going to start right there. There's more here that's alleged on the class membership question than the plaintiff's negligence. As you acknowledged in Tulo and has been acknowledged by the 1st DCA, one of the facts or arguments made by the defendants is that the smoker was negligent in continuing to smoke after they learned about the harmful effects. And yes, sir, Judge Sicklin, that is addressed in comparative fault, but that's not all they argue. To respond on addiction causation, a primary argument by them was, and they say it in their brief, this person didn't smoke because of addiction. This person smoked because they chose to. They used it to relieve stress. There was a lot of testimony about Miss Collar when her daughter died and smoking to relieve stress. They also focused a lot on, now Miss Collar, this is a living plaintiff, didn't you choose to smoke when you went out with your boyfriend and you were in that social circumstance? Now, are they allowed to argue that as causation? To explain her conduct, yes, but listen carefully to what it is. There's nothing negligent. It's not negligent conduct to go out with your boyfriend and smoke cigarettes. It's not negligent conduct to pick up cigarettes when you're under stress. Is it an explanation that they're allowed to give to say those silly plaintiffs have not proved addiction causation? Yes, they may. But all of Florida's case law that says, hey, not when you involve a plaintiff's conduct, deals not with plaintiff's conduct, but with plaintiff's negligence. This ain't that. So the way they tried this case, they can't make that argument. Add to that, the jury heard something else. The jury heard another explanation or contributing cause, substantial contributing cause. Not only is it the addictiveness, what happens to the chemical impact of the neurons on the brain, it's also the fact that this individual, thanks to the fraudulent concealment conspiracy, wasn't getting the information. And based on that, didn't know that they should quit. That's also a concurring cause. Was her lack of knowledge about what she was subjecting herself to, is that her negligence? No, it's not. Now this was all compounded by, on both of these errors, Judge Cox gave conflicting rulings or made conflicting rulings. Remember that she did give concurring cause in the context of fraud. She did help the jury understand, hey, when you get to the fraud causation question, you can have different reasons and explanations afoot, and you only have to find the one that relates to the defendant to be a substantial contributing cause. But she left that out of class membership. So that compounds the harm. Your law unequivocally says, by this court and the DCA's and the Florida Supreme Court, failure to give a concurring cause is reversible error when the facts, as viewed by the plaintiff, because it's the plaintiff who asked for it, requires it, and the jury can be misled. That's exactly here. The facts required it, and the jury was misled. The jury was misled by the evidence alone, but let's add to it the arguments of the defendant. The two decisions that you've been on, Cohen, particularly Cohen, talk about how causation works. That's not how they argued causation for addiction causation. They argued things like, in the context of Dr. Sewin, does Dr. Sewin say nicotine was the substantial contributing factor because it made her smoke and she couldn't quit? You were on the panel in Cohen that just said it's not the substantial contributing factor, it's a substantial contributing factor. And we listed a whole bunch more comments made by them in their defense that made clear that this jury was misled. Misled by how they proved their case, by the conduct they pointed to, that was not negligence by the plaintiff, by how they argued the case to the jury, and then by Judge Cox ruling inconsistently on how concurring cause instruction should be given. Add to that, both of these errors alone invalidated the trial, invalidated the jury's accurate analysis of the first question, where plaintiffs usually fail in these cases. Add to that Dr. Sewin and the fact that only part of his expert opinion was allowed and the other part was not. It is harmful error. They say things like, Does Dr. Sewin say nicotine overpowered her? Mrs. Collar could have quit anytime she wanted to, according to Dr. Sewin. And then, harmless error, goodness gracious, from their own mouths. They hold him up as highly credible, saying he has no interest in the outcome of this case. That was a quote. Another quote. Probably knows Mrs. Collar better than anybody you heard from this entire trial. So they improperly lopped off half his testimony. So the jury only heard that the woman could quit. The jury did not hear that the only person that they hold out as being credible, who treated her, did not think she was addicted. They never heard that. And they never got concurring cause and how to understand how addiction works. So if the court has no further questions, the plaintiffs urgently and strongly ask this court to reverse for both of these errors that impacted the jury's ability to fairly and accurately decide the question of addiction causation, and I thank you for your time.
Okay, thanks, folks. All right, our next matter up is Dylan Samira versus